We are the largest foreign investor in the United States. $500 billion in the last 5 years alone, probably $8 trillion in the next 5 years if we get the agreement that we expect to get.
Imagine a scenario where the Supreme Court orders the complete dissolution of a major American corporation tied to a prominent political figure. What would that look like? What legal principles would apply? And what would it mean for markets, politics, and the rule of law? Today, we're examining a hypothetical corporate dissolution case to understand the legal framework, business implications, and precedents that govern such extraordinary situations. Before we dive into our hypothetical scenario, we need to understand what corporate dissolution actually means and under what circumstances courts can order it. Corporate dissolution is the formal legal process of ending a corporation's existence. There are two types: voluntary dissolution, where shareholders decide to close the business, and involuntary dissolution, where courts force a company to cease operations. Involuntary dissolution is rare and reserved for extreme circumstances. According to corporate law experts, courts typically consider this remedy only when a company has engaged in systemic illegal activity, persistent fraud, or when the corporate structure itself enables ongoing violations of law. The legal standard is high. Courts must find that less severe remedies, such as fines, restrictions, or compliance monitors, would be insufficient to prevent future violations. This makes involuntary dissolution one of the most drastic interventions the legal system can impose on a business entity. Historical precedents exist, though they're uncommon. The dissolution of Arthur Andersen following the Enron scandal is perhaps the most famous modern example. After criminal obstruction charges, the accounting firm effectively collapsed, with thousands losing their jobs and clients scrambling to find new auditors. That case established important principles. First, corporate dissolution can occur even for firms with decades of operations and sterling reputations. Second, the consequences extend far beyond the company itself, affecting employees, clients, creditors, and entire industries. And third, the legal system will intervene when institutional misconduct reaches a threshold that threatens market integrity. Now let's construct our hypothetical scenario. Imagine a large real estate and branding organization led by a politically prominent figure. Over several years, multiple investigations uncover patterns of alleged financial misrepresentation. In this scenario, state attorneys general and private litigants file civil cases alleging the organization systematically inflated asset values when seeking loans, while deflating those same values for tax purposes. Financial statements submitted to banks purportedly showed properties worth hundreds of millions more than statements submitted to tax authorities. Investigators document these discrepancies across multiple properties and transactions spanning years. The pattern, they argue, isn't accidental or isolated. It's systemic, built into how the organization operates. Lower courts hear the evidence. Expert witnesses testify about standard accounting practices, real estate valuation methods, and financial disclosure requirements. The organization's defense argues that property valuation involves subjective judgment and that discrepancies reflect differing appraisal methodologies, not fraud. However, courts find the evidence compelling. Judges note internal communications showing awareness of the discrepancies, testimony from former employees about pressure to manipulate figures, and expert analysis demonstrating the improbability that such consistent patterns could be accidental. The case eventually reaches the Supreme Court. By this point, lower court findings have established a pattern of conduct. The question before the justices is not whether violations occurred, but what remedy is appropriate. The organization's attorneys argue that dissolution is excessive, that fines and oversight would suffice. They emphasize the economic impact on employees and partners, the unprecedented nature of dissolving such a prominent entity, and the potential political implications. Prosecutors countered that the corporate structure enables ongoing violations. They find the evidence compelling. Judges note internal communications showing awareness of the discrepancies, testimony from former employees about pressure to manipulate figures, and expert analysis demonstrating the improbability that such consistent patterns could be accidental. The case eventually reaches the Supreme Court. By this point, lower court findings have established a pattern of conduct. The question before the justices is not whether violations occurred, but what remedy is appropriate. The organization's attorneys argue that dissolution is excessive, that fines and oversight would suffice. They emphasize the economic impact on employees and partners, the unprecedented nature of dissolving such a prominent entity, and the potential political implications. Prosecutors counter that the corporate structure enables ongoing violations. They argue that leadership has shown repeated unwillingness to comply with legal standards, and that only structural dissolution can prevent future misconduct. In our hypothetical, the Supreme Court issues a detailed ruling that becomes a landmark in corporate accountability law. Let's examine the legal reasoning. The justices acknowledge the severity of ordering dissolution. They note this is among the most drastic remedies available and should be used sparingly. However, they establish several principles that justify this extraordinary measure. First, the court emphasizes the systematic nature of the violations. This wasn't a single error or isolated incident. Evidence showed a pattern spanning years across multiple properties and transactions. The consistency of the misconduct indicated it was embedded in operational practices. Second, the court addresses the question of less severe alternatives. Could monitors, fines, or compliance programs solve the problem? The justices review evidence showing previous court orders had been ineffective. Despite earlier judgments and restrictions, the pattern continued. Third, the court considers the corporate structure itself. They found that centralized control and lack of independent oversight created an environment where misconduct could persist without internal checks. The organizational structure, they concluded, was inherently prone to enabling violations. Fourth, and critically, the court addresses the argument about political prominence. The justices explicitly state that the legal analysis must be identical regardless of who leads the organization. The principle that no one is above the law means corporate accountability cannot vary based on political status or public visibility. The ruling orders complete dissolution. All operations must cease, assets must be liquidated under court supervision, and the corporate entity must be formally terminated. Trustees are appointed to oversee the process, ensuring creditors are paid appropriately and that no reorganized entity continues the same practices under a different name. When news of such a ruling would break, financial markets would react swiftly. Let's analyze the likely economic implications. First, any publicly traded entities connected to the organization would see immediate volatility. Investors would scramble to assess exposure, leading to rapid selling. Even tangentially related stocks might experience pressure as the market processes uncertainty. Second, the real estate sector would feel specific impacts. Properties bearing the organization's brand would face valuation questions. Licensing agreements would be examined, partnerships reconsidered, and lenders would review their exposure to similar risk profiles. Credit rating agencies would likely issue reports analyzing what this precedent means for corporate governance. They might adjust methodologies for assessing politically connected businesses, recognizing that political prominence does not shield companies from legal accountability. However, broader market reactions might be surprisingly muted after the initial shock. Economic analysts would emphasize that this represents the legal system functioning as designed. While dramatic, it does not indicate systemic market failure or unpredictable regulatory overreach. Warren Buffett's perspective would be particularly valuable here. As a respected investor, known for emphasizing corporate governance and long-term thinking, his analysis would carry significant weight. Buffett has long emphasized that companies must operate with integrity, that reputation matters, and that sustainable business success requires adherence to legal and ethical standards. In this scenario, he might note that while the specific case is dramatic, the underlying principle is straightforward. Businesses that persistently violate legal standards cannot expect to continue operating indefinitely. His commentary would likely focus on what this means for corporate America broadly. When institutions enforce rules consistently, it strengthens market integrity overall. Investors gain confidence that standards apply equally, which benefits legitimate businesses and ethical actors. Beyond markets, such a ruling would create significant political reverberations. Let's examine how different stakeholders might respond. For the individual whose organization was dissolved, the political impact would be substantial. A business empire often serves as tangible evidence of success, competence, and capability. Its forced dissolution would challenge that narrative. Political allies would face difficult decisions. Some might defend the individual, characterizing the ruling as excessive or politically motivated. They might argue that the legal system was weaponized or that the standards applied were unfairly stringent. Others might maintain cautious distance, acknowledging the court's authority while avoiding specific criticism. This approach allows them to respect judicial independence without explicitly defending the conduct that led to dissolution. Opposition politicians would likely emphasize accountability and the rule of law. They might characterize the ruling as evidence that institutions can function properly. Within the affected political party, internal tensions would emerge. Primary voters loyal to the individual might view the dissolution as persecution, potentially increasing their support. However, general election voters and moderates might view it as disqualifying, creating strategic challenges for party leadership. Congressional responses would vary by district and constituency. Representatives from safe seats might take strong positions, either defending or criticizing the ruling. Those in competitive districts would likely be more measured, recognizing that their response could become a campaign issue. The media landscape would be predictably divided. Some outlets would frame the dissolution as appropriate accountability. Others would characterize it as an overstep, and still others would focus on the legal and business aspects while minimizing political interpretation. Perhaps most significantly, such a ruling would establish important legal precedent. Let's examine what it would mean for future cases. First, it would clarify when involuntary dissolution is appropriate. Courts could cite this case when determining whether corporate misconduct justifies such extreme intervention. The standard would be clearer: systematic violations, ineffective lesser remedies, and structural enablement of illegal conduct. Second, it would address the question of political prominence. By explicitly stating that analysis does not change based on who leads an organization, the court would establish that political status offers no shield from corporate accountability. Third, it would influence how other corporations approach compliance. General counsels and boards of directors would study the case carefully, understanding that persistent violations, even in areas sometimes considered gray zones like property valuation, carry existential risk. Legal scholars would likely debate the ruling for years. Some would praise it as necessary accountability. Others might worry it sets a precedent for excessive intervention. Still others would analyze whether the standard could be applied consistently, or if it requires such extraordinary circumstances that it remains essentially unique. For the legal profession, the case would become a teaching tool. Law schools would use it to discuss corporate law, remedies, political accountability, and the intersection of business and politics. Students would examine the evidence, the reasoning, and the consequences. Internationally, the ruling would be noted as well. Foreign investors and companies operating in the United States would observe that even politically connected entities face serious legal accountability. This could enhance confidence in American legal institutions, demonstrating that the rule of law applies broadly. Beyond this specific hypothetical scenario, let's consider what such a scenario teaches us about corporate accountability in modern America. The dissolution of a major corporation led by a prominent figure would represent a significant moment in business history. It would demonstrate that size, fame, and political connections cannot permanently shield companies from legal consequences when violations are serious and persistent. This aligns with other landmark cases in American corporate history. From antitrust actions against Standard Oil to the breakup of AT&T, from tobacco company settlements to financial crisis prosecutions, the pattern is clear. When institutions determine that corporate conduct threatens public interest or violates fundamental legal principles, intervention occurs. What makes this hypothetical distinctive is the political dimension. Most major corporate accountability cases involve companies led by business executives, not political figures. The intersection of business misconduct and political prominence creates unique dynamics. This raises important questions about conflicts of interest, about whether political involvement should influence how we view business conduct, and about whether political figures should be held to higher or different standards when operating businesses. Legal experts generally agree that standards should be consistent. A financial misrepresentation is equally problematic whether committed by a political figure or a private business person. The law should apply equally. However, the practical realities of enforcement, media attention, and political pressure create complexities. So what can we learn from this hypothetical corporate dissolution scenario? First, the legal framework for involuntary dissolution exists and can be applied even to prominent corporations. While rare, courts have the authority to order such drastic remedies when misconduct is systematic and structural. Second, financial markets would react to such news, but the broader economic impact might be limited. Investors understand that individual company failures, even dramatic ones, do not typically threaten overall market stability. Third, political implications would be significant and complex. Responses would vary based on party loyalty, electoral considerations, and individual assessments of the legal merits. Fourth, such a ruling would establish important legal precedent, potentially influencing how other companies approach compliance and how courts evaluate future cases. And finally, it would demonstrate that American legal institutions can hold even the most prominent entities accountable when evidence supports such action. This hypothetical scenario helps us understand the legal principles, business implications, and political dynamics that would emerge in such extraordinary circumstances. While corporate dissolutions of this magnitude remain rare, the framework exists and the precedents provide guidance. Understanding these principles matters because corporate accountability, rule of law, and the intersection of business and politics are fundamental to how our economic and legal systems function. If you value this kind of analytical, educational content that examines complex legal and business scenarios, subscribe to News Vault. We break down complicated topics using clear reasoning and balanced analysis. What other legal or business scenarios would you like us to analyze? What questions do you have about corporate accountability or legal remedies? Share your thoughts in the comments below. I've linked to resources about corporate law, dissolution precedents, and business accountability in the description below for those who want to explore these topics further. Thanks for watching News Vault, where we examine the principles that shape law, business, and policy. I'll see you in the next one.